like our numbers dwindled a little bit. Good morning. We're here for oral argument in case number 1 CACV 18-0404. In the matter of Karen K. Hefner and Gary S. Hefner. Council, remind you that this is being audio and video recorded, so I please ask you to identify yourselves and your clients at the beginning of your arguments. Each of you will have 20 minutes. You're not required to use all that time, but you're welcome to. If you're appellant's counsel, you're responsible to watch the clock and reserve a portion of whatever time you'd like for rebuttal. Also, please keep in mind we've read the briefs and have discussed this case in conference, so we're at least I think we're pretty familiar with the procedure and the overall facts of the case. With that, counsel for appellant, you may proceed.
Thank you, Your Honor. May it please the court, Glenn Halterman, appearing for appellant Gary Hefner. Starting with the personal injury proceeds issue, Supreme Court in Zurich clearly established the method by which personal injury proceeds are to be divided and apportioned between an injured spouse and the marital community. What is interesting, perhaps what is important as what Zurich says is what it doesn't say. It doesn't say that a court should determine what portion of the personal injury proceeds are for pain and suffering and then award the remainder to the community. It doesn't say that.
Well, counsel, what was the nature of your papers that you submitted to establish a proportion of the settlement that was separate?
The documents that, well, we did not attempt to prove what portion was separate. We put into evidence of what was community in nature. There were medical records or medical bills that had been paid by the community. The amount out of pocket by the community was a little over $1,200.
So you established what was subject to you started out kind of in the inverse from what we're talking about. You started out with well, here's our damages, as opposed to starting out with here's our money.
Well, everybody knew what the money was, at least on the first automobile accident claim. And so there was a pot of money of $70,000.
Good with you so far. Go ahead.
And then at that point, what Zurich says to do to the court is figure out how much of that $70,000 is to recompense the marital community for actual loss, for either medical bills that were paid or lost wages. So from our position, well, not just from our position, there was no lost wages claim. That was never a part of it. So lost wages was not a part of any calculus of what would be community property. And
You're saying there was no lost wages?
There was no lost wages claim.
So just medical.
Just medical
bills. Do you recall, and I understand your argument regarding actual payments, but roughly what was the amount of medical bills, whether reimbursed or not? I mean, total medical bills.
I believe it was approximately 100,000. I think it was approximately 100,000 for each of the separate claims. There was accident 1 and accident 2. I believe it was about 100,000.
100,000 was what?
Were the medical expenses that were incurred. The marital community didn't have to pay $100,000 out of pocket to pay for these medical expenses. There was only a small amount, about $1,200, just over that amount.
Because insurance paid for it?
Insurance paid for it, or write-offs or write-downs. So the marital community in this situation only experienced a very slight detriment.
So you presented that evidence of the $1,200 and then asked the trial court to say, okay, then the rest under Zurich then the rest is for personal,
Correct.
lots of personal, it's sold in separate property.
Correct, exactly.
And the trial court's response was,
The trial court's response was, you didn't prove how much was for pain and suffering, and or your evidence that you presented as to what was community, the community bills was not sufficient. I think both of those are incorrect, but the way that the trial court approached this was exactly the opposite of what the Jurek court says to do. It says, take the pot of money, you get personal injury proceeds, trial court, figure out how much is for actual loss to the community, and then the remainder is stolen separate property.
Would the insurance company have some right of subrogation
They-
as to those funds?
They would not, Your Honor, or at least in this, if there is, that's a separate issue from what's sole and separate and what is community, if there was a
They
subrogation
didn't
claim.
make a claim against any portion.
Pardon me?
They didn't make a claim against any portion of it, the insurance company?
I don't believe so, not on accident one, that was,
So there wasn't a third hand in the pot?
there was not.
And were your demand letters involved in this, in litigating this issue?
Yes, the demand letters were submitted to the court. They could see, I believe the demand initially was $130,000, and it settled, well, there were two claims. So the one that settled for $88,000, I believe, started with a demand for $130,000. I don't know that what was initially demanded, though, and what was eventually paid is really germane to how the trial court should have calculated the community interest.
Well, I understand your legal theory, but
Okay.
in these demand letters, did you break it down as to what the components of your demand were?
No. So we weren't the counsel for the
Okay.
on the personal injury side, and there was a breakdown of the medical expenses of what had been incurred, and I think there were about 46,000. So I said 100,000 for both. I think the combined amount. So there were two accidents, and I think the combined medical expenses were probably 100,000 between both of them. On the demand letter that was admitted into evidence, that one I think showed about 46,000 in medical expenses, not medical bills, but not expenses that were paid by the community.
How long did your discussions towards settlement go? If we're looking for correspondence, very good process of what always takes place in these cases where you start with I wish you would give us, and you get down finally to the, okay, here's the least we can settle for. What were the parameters of that? Do you remember?
I don't know. The only evidence that I saw was the demand letter asking for 130, and I didn't see any other response from the insurance company or anybody else.
Now, you've talked about Jurek, which was in 1980, but apparently we held in the Gersten case in 2009 that it was appropriate to characterize the recovery as community property where the receiving spouse, quote, did not demonstrate what portion of his benefits, if any, constituted compensation for injury to his personal well-being, quote, unquote. How does that square with?
The difference is in Gersten, the funds that were at issue were FICA benefits, which the court held were specifically for compensation for work or being out of work. Personal injury proceeds are very different. They are exactly the opposite purpose. So that's why Gersten is an opposite in this situation, because of the type of funds that we're talking about, FICA benefits versus personal injury proceeds.
FICA benefits are just federal,
But,
they're
yeah,
the equivalent to workers' comp.
probably
but they're-
workers' comp
they're
disability.
somewhat equivalent.
Yeah, so you're compensating the person for lost wages. It's a lot, essentially, I think a lost wages claim is a fair way of looking at that.
You don't get, you're not entitled to injuries for pain and suffering
Correct.
in the workers' comp arena.
Right, Right.
But what about loss of earning capacity, which would extend beyond the date of, that the marriage concludes?
Loss
For,
of
ex-
earning?
for example, in Hatcher versus Hatcher,
Yeah.
there was a recovery from
Right.
disability policy. And the recoveries was for lost wages, actual lost wages and future lost earning capacity.
Mm-hmm.
And we held that, well, at least a portion of this is personal to the injured worker spouse, but to the extent that the lost earning capacity extends into the future and beyond the marriage, that part is his.
Right.
The part during the marriage belongs to the community. So, I'm not sure that Gersten's still not in play here.
Well,
But we apparently said that it was the receiving spouse who has to establish how much is personal or separate to him.
right. But in Gersten, again, we're talking about funds that are specifically for the compensation of the community for lost wages. And that's in Jurek says, yeah, you do that in Jurek, but you do that first. You figure out what that number is for lost wages, take it out of the personal injury proceeds, and then the rest goes to the damaged spouse. So it is a different, the approach is different. It does put the onus, Gersten and or Hatcher, or Gersten does put the onus on the person wanting to prove sole and separate nature of FICA benefits, but that was going to be a futile endeavor anyway, because FICA benefits are not for personal injury. So that,
But they are for loss of earning capacity. Like,
right,
so if you
which is community.
Yeah. Well, not if
Partly.
you get partly. What if you get divorced in 6 months after the disability? I mean, the earning capacity is going to go on for years potentially. The loss of earning capacity.
Sure, but that would inure to the benefit of the injured spouse, not the community.
Yeah. I mean, it's interesting. I'm looking at Gershon right now, and in paragraph 19, it said the husband did not demonstrate to the family court what portion of his FICA benefits, if any, constituted compensation for his injury to his personal well-being. I'm not exactly sure what since I was on that panel, I noticed what we meant by that statement.
So the difference is, in Gersten, if he couldn't prove what was sole and separate, then the remainder was going to be community. Jurek says, if you can't prove what's community, then the remainder is going to be sole and separate. It's a completely different analysis. It's completely opposite.
We're trying to square them, I think.
Pardon me?
We're trying to square the two approaches.
Yeah, and I think the reason, I think the policy behind the Jurek approach makes a lot of sense. One thing I mentioned in our briefs was sometimes it's not entirely possible to calculate how much is for pain and suffering, but it is easy to figure out how much did we pay for medical bills and how much were the lost wages. Those are readily calculable. And so to start from the and again, Jurek goes to great lengths to distance, to set personal injury proceeds apart from other income that might come in to a marital community. And it says it's not like everything else. It's different, and we got to treat it differently. And that's why at the end of Jurek, they set up a very, what I think, elegant way to address the situation and do so equitably. Personal injury can affect the marital community and not just the person being injured, because the marital community can lose wages, they can incur medical bills, and Jurek accounts for that and says, let's take care of the marital community. We recognize the harm that was done, but the primary purpose of a personal injury proceed, the proceeds of personal injury case, is to make the injured party whole, not to give a windfall to the marital community.
Were these settlements the result of of the filing of causes of action, or were they just didn't negotiate with the insurance company without anybody filing a complaint?
I honestly don't know, Your Honor. As far as the issue about actual, it talks about actual loss, I think we have to take that literally. Actual loss for medical expenses or lost wages is not potential loss. It's not avoided loss. It's not the loss that would have occurred but for the fact that the marital community had medical insurance. It says actual loss. And so to calculate the marital community based on medical bills that might have been issued to the parties, but which were eventually paid by an insurance company, is not actual loss. That's a fiction.
And that's undisputed evidence that it's undisputed essentially that that insurance paid everything except for the $1,200 essentially.
There wasn't any countervailing evidence at trial, Your Honor, that there were more expenses or that the medical bills were higher.
Well, but apparently the judge rejected your evidence about what the separate property was as opposed to the community property.
She did. That's why I'm here.
Well, I mean, I guess we defer to that unless there's some reason not to, right?
Well, but here's the issue. We didn't have the burden to prove what the community portion was. If the separate portion, or I'm sorry, if the remainder, as Jurek says, is going to go to the injured spouse, and it should, and it does, and that's what Jurek says it has to happen, then the other party has the motivation to prove and present evidence as to what the community, how the community experienced loss. To have father, or husband in this case, have the burden of providing evidence that's going to be detrimental to his own financial well-being is just completely opposite of how we allocate evidentiary burdens.
Sorry, aren't you, just to clarify, aren't you also arguing that you did meet the burden of proving what was actually community?
That is an alternative argument, that if you were to not agree that Jurek demands that wife in this case have the burden of proving the community interest, that husband still presented adequate evidence that would support that claim. Again, that's issue 2 in my first brief, and that's only if we don't get past the first one. But I should probably reserve a little time for rebuttal at this point. Thank you.
You.
Good morning, Your Honors. Lee Richard appearing on behalf of the petitioner appellee cross-appellant Karen Hefner.
Counsel, I forgot to mention that because you filed a cross appeal, you can reserve some time for rebuttal on the cross appeal if you'd like.
I think I'll just do it in one shot, Judge.
Okay, all right, sounds good.
All
Yes.
I know it's getting late for lunch. So, Judge, a couple of things. First, the PI, personal injury proceeds. The court's absolutely correct. Gersten applies here. There is no distinction between, for our purposes here, which is who has the burden of proof, there is no distinction within the context of community property law between federal workman's compensation, which has multiple components in it. It has both, and if you look at Gersten, it addresses that. It has both a lost wages component, a medical expense component, which the court says are clearly community properties. Then all you do is you replace the words pain and suffering with injury to personal personal benefit, I think is what it says.
Personal well-being.
Personal well-being. Just replace injury to personal well-being with pain and suffering, and you got the exact same template that you're working with. And this court in Gersten said okay, it's the burden of, under community property law, which applies, any property acquired during marriage is presumed to be community property, and it's the burden of the party who is claiming that property as sole and separate property to prove the amount by clear and convincing evidence. And that's all Gersten said.
But how do we deal with this Jurek instruction that the Superior Court should determine the actual loss to the community for loss of wages and medical expenses and divide that as community property, and the rest is sole and separate property?
It's easy, Judge, because this is that's a very practical approach. Remember,
But this is the Supreme Court
backwards.
talking. And
but-
Gersten is our court.
and understand, though, put it in context. What happened is prior to that, the Arizona law said, yeah, it's all community property, you
Right.
go. Jurek came down and said, we're now establishing a new law. We're going to carve out a section to be sole and separate. Fine. The only instruction down to the Court of Appeal, it could have been a variety of things, but the court said, remanded it and said, okay, trial court, figure out what components are community property and what parts are, and the rest will just be deemed sole and separate. Interesting there, though, is it doesn't say who has the burden of doing that. It doesn't place the burden on the party. It doesn't say the party who's claiming sole and separate doesn't have the burden. It's now on the party claiming community property. It just directs the court to say, go back and look at this. And why did the court maybe argue to say, let's look at the community part first rather than the pain and suffering part? Well, just as a practical matter. It's much easier to establish lost wages and medical expenses are much easier to objectively measure than it is to try to measure some kind of unquantifiable thing such as pain and suffering.
Well, what are we to do with a demand letter that, for purposes of settlement, that says, well, the community suffered $100,000 in
Well, that's not what
medical expenses?
Yeah, let's talk about demand letter. And it's really what this boils down to, Judge, is it's a failure of evidence in the trial court. And that's what the trial court said.
Well, the trial court apparently rejected the appellant.
Because here's what the husband presented. He presented one old initial demand letter that only mentioned medical expenses of $46,000. It doesn't reference any lost wages. It doesn't reference.
This is as to one accident, is it?
Yeah, this is it. This is the totality of what husband submitted at the trial court. This one old first initial demand letter to the insurance company, and then a schedule with a list of some medical expenses showing like $1,900, and that was the totality of what they submitted.
Nothing about insurance.
Nothing about insurance. There's nothing in there about lost wages. There's nothing in there about pain and suffering. In the demand letter, there is no demand for pain and suffering.
I'm talking in the record at all. Is there anything about whether health insurance paid for husband's medical bills?
I don't. I can't.
Because where I'm going here is it says that the Supreme Court has told us actual loss to the community. I mean, that's pretty specific. What actual loss was there to the community here?
Well,
other than the $1,200 that counsel alleges.
Well, Judge, I'm thinking that to the extent that you're trying to read in a presumption that somehow the Supreme Court intended to overturn and reverse the presumption of the burden of proof to say.
I'm not talking about burdens. If I don't care who has the burden of proof, there needs to be reasonable evidence in the record. I mean, supporting the trial court's ruling here. And I don't think you can just say it just all goes to community. If there's any evidence to the contrary about what actual loss is, I mean, doesn't the trial court have to account for that?
I think what the trial court said is there was not sufficient evidence to establish how you allocate, just like in Gersten, how you allocate out whatever the losses were because what we did was they got a payment of, I think it's $99,000. That $99,000, there was no allocation out between what it was for. There's no allocation of what that cash that came into, because the rest is academic, that cash was for.
Sibyl, let me give you an example of how I think it's supposed to work. In Hatcher versus Hatcher, the couple had disability insurance, and the husband lost his arm and his hand, or part of lost his hand and part of his arm. And then he got money from the insurance company. The trial court attributed it all as to his separate estate. But we just looked at it without reference to presumptions and just said, well, he has suffered both a loss of actual earnings during the marriage, and he will continue to suffer from a loss of earning capacity in the future after he's divorced. And we said there's components of each in there without regard to presumptions. But here, do we know? Is it all community? Is it all separate? We don't know what he got.
Well, and that's part of the issue, Judge. We don't know what he's got. So then once you overlay the issue of community property on it, whose burden was it to come forward and say, this is what I have? Jurek didn't say that you have to go back. First of all, Jurek went back and said, remember, because it was establishing new law. And so the trial court didn't have the ability to go back and allocate things because that wasn't the law at the time. But as a practical matter, now the court knows, and the trial court knows, it's supposed to allocate out what's supposed to happen. But overlaying all of that is still the presumption that the burden is on the party claiming that it's sole and separate to show what component of that is sole and separate. That's the difference between the Jurek thing. Jurek was a new order that the trial court, that's new law that the trial court did not apply and have the opportunity to apply at the time, because there was no breakdown.
Jurek doesn't have anything to do with burden of proof. It didn't change.
It has nothing to do with community property. If the Supreme Court was going to completely reverse a long-standing presumption of community law and who has the burden that any property acquired during marriage is the burden of the party claiming it to be sole and separate or a component thereof, you would think that the Supreme Court would say that's what they intended. They didn't intend that. The direction was simply a practical matter. Trial court, we know you didn't address this below because you didn't have to address it because the law is different. We're now sending it back for you to address. But over and above that, that's all they said. They're not changing the presumption, the legal presumption. So what really went on here is there was just a complete failure. Husband didn't submit any evidence about what the $99,000 was for. Yeah, he threw some numbers out there and said, well, here's some medical expenses, and here's kind of a demand for medical expenses, but there's no demand that was made for, no demand even in the demand letter for pain and suffering. We don't even know if that was pled. There's no demand in there for, we don't know what lost wages were. We don't know if there were property damages.
Was there a pleading? Was there a complaint?
Nothing that was, the only things that were submitted at the trial level was this old three-page demand letter and a schedule that husband created on his own saying these are my expenses and what I had in the medical expenses.
Now, if complaints had been filed and the issue gone to juries, and let's say that the total in medical expenses was $100,000, even though a bunch of that was paid by an insurance company, the plaintiff's going to get what? They're going to get the $100,000, aren't they?
I guess I'm not following how that applies to this particular case.
Well, you don't
Judge.
go to a jury and say, well, the insurance company paid $99,000 and I paid $1,000, do you?
No, I mean, the problem you're going to have is most likely, is even when you deal with settlements with whether it's with the insurance company or whether you get a jury award, jury award may break it out, is that they don't break it out for you. But the problem is, Judge, is that it's clear that somebody could, look at the Texas cases. The Texas cases address this issue head on, and they say, no, you can come forward with evidence to show that this amount was what I got for lost wages. This is what I got for property damage. This is what I got for medical. This is what I got for pain and suffering. There has to be some evidence. I don't know what the necessary quota is, but it's not here because, as the trial court properly found, there wasn't any evidence submitted. It's just husband coming in saying, yeah, I got this and it should all be mine. And the court said, well, it was your legal burden. Jury doesn't change the legal burden. It's your legal burden to establish what that sole and separate component is. You didn't give me anything. You haven't even shown that you even pled pain and suffering. And so it's all community. So I think that was a correct ruling. Now, if I may go briefly to the issue of my cross appeal, and that's on the nature of the Hefner Auto Repair, Inc. as a community. This really should be a fairly easy decision, especially based on the specific findings of the trial court itself. The trial court itself found that husband created Hefner Auto Repair, Inc. before he received anything from his father. And that's the big issue here. So there's no question about that. It was created before, and that's a finding of the court, and that's what the evidence showed, before he received anything from his father, before his father retired. It was created during the marriage, 17 years into the marriage, that's a finding of the court. It was created with the use of community funds and credit, another finding of the court. Husband properly admits in his brief and below that under Arizona community property law, property takes its character as community or separate at the time of acquisition. And that's what the court applied that law here, because the court said specifically that the corporation was acquired during the marriage, and therefore it's presumed to be community, and it was husband's burden to overcome that presumption by clear and convincing evidence. The court what the court did at that point is that it got hung up on this concept of gift from father to son. Now, the problem with that is twofold. One, there was no establishing exactly what the gift was. No, husband's never been able to identify exactly what it was. The court's never identified what it was.
Wasn't it an auto repair shop? I mean, to put it pure, just plain and simple, it's an auto repair shop.
Well, but what does that mean as a practical matter? It wasn't the property.
Sure, it means it's people that come there to get their car fixed.
Okay, but that's fine. But is that clear and convincing evidence that what the value of that was, or what?
Whose
exactly
job was it? Whose burden was it to establish a value?
Our position would be, to the extent that he wanted to show that it's sole and separate property, that it would be husband's value. Well, to the extent that that's an issue. But see, this is the problem where the court went down this rabbit hole it didn't need to go, because the issue is, no matter what it was that husband got, and we don't know what it was, it doesn't matter. It's irrelevant, because it was contributed to Hefner Auto Repair, Inc. And that's what the court found. The court found that that the corporation was formed first. It was a community corporation. Then husband's father retired. Then husband got something from his father, and then they operated as a Hefner Auto Repair, Inc. under the new form for the next 17 years of the party's marriage, using community funds, to have started the original community corporation. Under the law, that whether husband gave him $500,000 or father's husband gave him $500,000 after that fact, or whether he got some loose change and an old mint in the cash register, didn't really matter, because whatever it was, he contributed it to the corporation, and that's what we valued. That's what was the ongoing concern for
Why was the corporation community property?
Because it was formed during the marriage. It was formed with community monies. It was formed with community labor and effort. And the trial court found that it was community property. Initially, it found it was community property. It was presumed to be community property.
By gift? By gift to the corporation?
No, the original corporation, Hefner Auto Repair, Inc., was created. Remember, father was just him working. It was just a DBA. It was just dad working. There was no corporation. There was no partnership. There was no LLC. There was just him. And when he what he gave to his son was not the building, was not the property, was not the cash, wasn't any of the accounts. He kept all that himself. There's no identification of whatever he gave to his son. There were no receipts.
Well, it's goodwill or something, right? I mean,
we don't know. We don't know if there was goodwill. We don't know how many. There was no client list, no inventory, no financial statements, no accountings, no agreement, not even a gift tax filing that was done. There's nothing to show what father gave to son during this time. All we know is that, according to the court's own findings, is that, and the party's testimony, is that whatever it was that father gave the son was used and contributed to the corporation that husband had created and established as with community funds and community effort and labor before father retired and gave him anything. Now then later, about 8 months before, 17 years later, and about 8 months before the filing of the divorce, father then transferred the property and the building and everything to husband. But that didn't really play into anything in this case because we gave husband credit for that. We value wife had the business Hefner Auto Repair Inc. valued, and that by a professional appraiser, and that professional business appraiser said it was worth $220,000, not including the building, the lots, or any of that stuff that went to husband separately from the company as his sole and separate property. Husband did not challenge that appraisal at trial, did not call their own appraisal expert to challenge that appraisal. All he did was say, well, it's mine because my father gifted it to me. And it's like, well, no, one, you don't know what your father gifted to you, but in any event, whatever you got from your father 17 years ago, you put into Hefner Auto Repair Inc., which you created beforehand. So the law, which the court properly found, and which husband correctly states, is that when Hefner Auto Repair Inc. was formed with community funds during the marriage, it became a community asset. And that doesn't change. And the fact that he decided to contribute perhaps sole and separate monies, sole and separate whatever, sole and separate goodwill, whatever it was, the fact that he contributes that stuff to that community property doesn't affect the sole and separate, the community nature of that corporation. It'd be the same as if he inherited, he's got a company going and he got $100,000 from his parents as an inheritance, and he takes $100,000 and he says, you know what, I could use this to expand my business and the community business, and he throws it in there. Well, that's fine. It doesn't change the fact that the business is still a community asset. All he did was make a gift of his sole and separate money. And if he came forward and wanted to claim that, hey, I should get some credit back for the money and stuff that my father gave me, and I should get some credit for that, well, then it was his obligation to show exactly what it was. You would think that if somebody has a sole and separate claim for property, the first step in that is to clearly identify what that sole and separate property is. But we don't even have that here. So the trial court's getting gummed up on this after the fact, husband getting this gift, really it's a rabbit hole we don't need to go down, and it's confusing, and it confused the judge in the trial court. Quite frankly, it got it all balled up because it's after the fact. It doesn't matter what it was. It was contributed to an established community business. If husband wanted to somehow claim some kind of interest from that, it didn't change the community nature of the business. If he wanted a credit, it was his obligation to come forward and establish clearly what it was that he got. And,
Thank you, counsel.
Thanks, Judge.
Glenn Halterman again for Gary Hefner. With respect to the timing of the creation of the Hefner Auto Inc., if the court were to find that this was a community asset, it would be the ultimate in form over substance. There is no doubt, and there is no contrary evidence really in the record. I think that's safe to say that Hefner Auto Repair Inc. formed 2 weeks or so before the gift occurred, was done as a coordinated and contemporaneous effort to get this business plan in place to allow him to take over this property. There was no sense of there was no community involvement or intent here at all. the fact that Roe, in Roe, the Roe case, there is an incorporation that occurs afterward. It's still a technically, you could say it was that the community acquired the property in Roe, but in Roe, the court said, this is not community. We're just taking one property, one asset, changing it to another asset. The fact that it happened 2 weeks before rather than 2 weeks after would be the ultimate in as I say, form over substance. I need, and then just very quickly on the burden of proof, Jurek absolutely changed the burden, the evidentiary burden for stolen separate or personal injury proceeds. The default in our law for personal or for property is that if you can't prove by clear and convincing evidence that it's separate property, then it's going to be community. It's acquired during the marriage. Jurek says the exact opposite. It says, trial court, figure out what's community, and the remainder will go to the separate interest holder. Our default typically is the remainder goes to the community. Jurek says the remainder goes to the separate property interest. There was additional evidence, Your Honors, regarding the medical bills that were incurred, not incurred, paid. So it was not just the demand letter and a schedule. There were also medical expenses that were shown that were paid. And it looks like my time's up.
Okay. All right, counsel, thank you both for your arguments this morning. The court will take this matter under advisement and issue a decision in due course. The court is now adjourned.